name is Shannon Hammond. I'm an elder law attorney, which means I do a lot of estate planning, but I would differentiate myself from a traditional estate planning attorney because I look at those documents in a way that will serve you as you continue to age, and I work with those documents on what I call the back end. So not just early in life, as people might be thinking, oh, I'm having kids, I should maybe get a will or a power of attorney, but then I'm working with adult children who are trying to assist their parents later in life. So I really have the advantage of seeing what works and what doesn't in your estate planning documents. Tonight I'm going to focus on the advance directive and healthcare instructions that you might make towards your end of life. But first I'd like to clarify some of the terms that are associated with this document. So we'll go through a little ABCs here. I'm also going to talk to you about the MOLST form, which some of you may have heard about, and try and give you a little bit more information about that. So there are many names for this document that you can sign to make healthcare decisions for yourself or express your wishes in the event that you're unable to make healthcare decisions for yourself later in life. Sometimes it's called a healthcare power of attorney, and that document is really limited to naming a healthcare agent and describing the general powers that that agent has to make medical decisions for you, like reviewing medical records, riding with you in an ambulance, authorizing your admission to or discharge from a medical facility, those sorts of general powers. That's a medical power of attorney. There's also a living will, which is sometimes a separate document, and it may not make any reference to who your healthcare agent is, but it's simply a statement of your wishes about life-sustaining treatment. It's usually limited to describing a persistent vegetative state, an end-stage condition, and a terminal condition, and allows the person executing the document to give instructions about what type of care they would or would not want to receive under those circumstances. So that's the living will. Then we have an advance directive, which is what I use in my practice because the advance directive, at least the Maryland Attorney General's advance directive, includes 3 parts. The first part is the healthcare power of attorney. It's called Part 1, Appointment of Healthcare Agent. And you name your agents and it describes their powers. And then Part 2 is the living will. It's called Part 2, Treatment Preferences. And then it goes through the terminal condition, persistent vegetative state, and end-stage condition. And Part 3 of the advance directive talks about after your death. So if you have instructions about organ donation or anatomical donation in general, or if you don't want to donate any part of your body, you can make that clear as well. And it allows you to make a statement about your funeral arrangements, if you prefer burial versus cremation, or if you own a cemetery plot somewhere and you want to make your family aware of that. So the advance directive includes all 3 pieces in one document. That's what I like about it. So you don't have a healthcare agent who has your power of attorney, or your healthcare power of attorney, so they're allowed to speak for you, but they don't have the living will. They didn't find that piece, and that's somewhere else in a different drawer, a different safe, so they don't know what your wishes are. So this way it's all contained in one document. There are also many terms used to describe the person who's making medical decisions for you. I guess the generic term might be healthcare proxy. You can have an attorney in fact, which is the person who is acting for you under any power of attorney. So you could have a financial attorney in fact, you could have a healthcare attorney in fact. There's a movement now toward just using the term agent under both documents. So a healthcare agent or a healthcare attorney in fact. There's also something called a surrogate decision maker. And the surrogate decision maker is a person who is identified by statute, which means there's a law in the Maryland Healthcare Decisions Act, or a provision in the Healthcare Decisions Act, which lists certain family members in order of priority who can make medical decisions for you, even in the absence of a healthcare power of attorney or an advance directive. I don't want you to rely on the surrogate decision-making statute as your form of planning for healthcare decisions, because as soon as you get to, let's say, adult children, and you have multiple children at the same level of priority, if there's a conflict or there's not a unanimous decision with regard to your health care, then somebody needs to jump up the list or increase their priority so that they are the ones that have the authority to make the final decision, which often requires something like guardianship. So don't think, oh great, there's a surrogate decision-making statute, I don't need to worry about my advance directive or my medical power of attorney. It's really there just in the event that you didn't get around to it, or for people that didn't think about it, somebody can step in and make decisions for you. And on page 2 of my materials, it lists for you those people in order of priority as they're named in the statute. And then lastly, as I mentioned, in some cases, it's necessary to have a guardianship. If there's a conflict among surrogate decision makers, if there is no healthcare power of attorney or advance directive, it's sometimes necessary to file for guardianship over a person who can't make decisions for themselves. And then the guardian of person would have authority to make medical decisions. We covered the content of the advance directive, but one thing I wanted to point out, based on all of the other materials that you've received tonight, is I prepare many of these documents for people that want to include all of the Catholic perspective, the spiritual support provision. I routinely include those things in the Maryland Attorney General's form, so I don't necessarily use the Catholic form advance directive, but I incorporate the Catholic language and the instructions and guidance that the church gives you into that form. So just so you're aware, you can incorporate all of those wishes and decisions about your health care into any advance directive. The important thing to remember is that although it specifically refers to those 3 medical conditions that I mentioned, the advance directive is for your healthcare agent to know what your feelings are about the end of your life and what types of care you do and don't want to receive. That could be in a terminal condition, it could be in a temporary condition, it could be because you're going in for surgery and you might be temporarily unavailable to make decisions for yourself. So you really need to be broad and give lots of instructions and explain your feelings and wishes in detail so that your agent is empowered to make those decisions for you. You don't want them to guess what you would have wanted. You want them to be informed based on the content of your document. I quickly want to mention to you, or bring to your attention, the MOLST form. You may have heard of a DNR order. If you've ever heard somebody say, I have a DNR order, which means do not resuscitate, that does not exist in Maryland anymore. We have replaced the DNR order with something called the MOLST form, which stands for Medical Orders for Life-Sustaining Treatment. And it is not a legal document in the sense that I can't prepare it for you. You can't Google it and prepare it for yourself. It has to be signed by a doctor or a nurse practitioner. And there are regulations that describe when this document should be completed. So for example, when somebody who's an inpatient in a hospital is being discharged to a rehab or long-term care facility, at that discharge, or part of the discharge planning would be to update the MOLST form, which is a discussion that your doctor would have with you about your different decisions you can make about life-sustaining treatment, artificial nutrition and hydration, CPR, all of these different types of treatment that we talk about in the advance directive, except the MOLST form is a medical order. So just to be clear, if you imagine how this would play out in a real-life scenario, if you're unable to make medical decisions for yourself, your healthcare agent is reading your advance directive. This is what is guiding your healthcare agent to make decisions for you. Your doctors, if you have a MOLST form, are following the medical orders that are in your chart. So is there a potential for conflict? Maybe your advance directive says one thing when you're sitting in the comfort of somebody's office making these decisions for yourself versus what you say when you're heading in for open heart surgery. There absolutely could be. But the MOLST form is so new that we haven't really seen how that's going to play out yet. But I can tell you that the doctors are following what's on the MOLST form. So you can ask your primary care physician. You don't have to wait until you're going into a hospital. You can ask your doctor to complete the MOLST form. Emergency personnel, EMS, if they were called in an emergency to your home, they're going to be looking for the MOLST form. They're not reading your advance directive. So both documents are important. I just want to be sure you understand the advanced directive is for your healthcare agent, the MOLS form is for medical staff and other medical emergency personnel.
Can I ask a silly question? Where would they look for it if they were in an emergency?
They look on your refrigerator or on your bedside table. And after that, they're not going to keep searching. The default would be to provide all available interventions to save your life unless they've found some document to the contrary. That's all I have. Thank you.